Welcome to episode 18 of the Extremely Non-Extreme podcast. I am the host, Quentin Wittrock. Today, we bring you the second in a series of podcasts about policy issues. The first was a deep dive into tax policy, and that was last month. We're exploring the 10 policy statements listed in my Principle-Based Politics blog post of November 24th, proving each one of them with individual guests. And I believe each statement to be a common sense policy position on which the vast majority of Americans agree. That policy statement today relates to business regulation. And my statement is this: reduced regulation allows business growth, which individual Americans need. My guest to discuss this is Patrick Walls. Pat has been the president, chief legal and operating officer of two national restaurant chains, and then became the CEO of a swimming pool supply company and the chief operating officer of a pool manufacturing company. All of those were heavily regulated businesses, as Pat will explain. Welcome to the program, Pat.
Hey, Quentin, thanks for having me.
The current Code of Federal Regulations consists of close to 200,000 pages. In 1970, there were 20,000 pages. This results in the feds being accused of running a nanny state that seeks to control every aspect of our lives, particularly the work lives of business operators. Let's start with your deep experience in the franchised restaurant industry, Pat. What are some of the federal regulations that impact those franchised restaurant businesses and franchising generally?
Yeah, thanks, Quentin. So as you said, 30-year career, been retired for a few years now, but most of it was almost all of it was in franchising, and most of it specifically in restaurant franchising, right? So when you ask a question like that, I have to start with franchising. And franchising itself is a highly regulated business, both from the federal and the state level. I know, part of this, as we discuss, will probably branch off a little bit into the states as well, because it's not just the feds that are creating a nanny state. In fact, a lot of the scary regulations, or what I would call scary regulations, really are happening at the state level in a lot of areas. But in terms of franchising, so franchising has been regulated since 1979, when the first franchise rule was enacted. And like a lot of regulations, it really came out of a good place, right? Or the wanting to come out of a good place. There had been a lot of fraud in franchising up to 1979. There had been a lot of people that were kind of taking the money and running, right? People that would sign people up to be a franchisee for a brand that really didn't exist. When they went to contact the person who sold them the franchise, they couldn't get a hold of them, right? So there was a good bit of fraud going on in franchising, and so the franchise rule was a reaction to that. Basically, what it said was, in order to sell franchises legally in the U.S., you had to have a disclosure document, something akin to a securities prospectus if you were going to buy a stock or you were going to buy a mutual fund. And that prospectus would have to be in the same format, whether you were a restaurant company, a restaurant franchise, a plumbing franchise, a hotel franchise, whatever the case may be. And it covered certain things that they felt a prospective franchisee should know about the business before signing an agreement or paying any money in order to get into the business. That rule was updated, has been updated a few times over its almost 50-year existence. Some of the disclosures have changed, but at the end of the day, it's still pretty true, I would say, to the rule that was passed in 1979. Beyond that, you have a bunch of states, about 23 states, that regulate franchising in terms of either having to register your disclosure document with the state or filing it with the state, or completing some kind of paperwork with the state before you could sell in that state or offer franchises to residents of that state. All of that obviously has costs involved, right? I mean, most franchisors could not comply with the franchise rule and write their own disclosure document, right? So they're going to go out, they're going to find a franchise attorney who specializes in this. And obviously, if you're going into some of these registration states, there's going to be an added level of cost from your franchise attorney. And so all this stuff isn't free, as I like to say.
Okay. Well, then at the franchised restaurant level or the franchised body shop level or whatever store the franchisee is operating, do they have regulations they face as well?
Sure. So they're going to have all the standard regulations to comply with that for the most part that they would have to comply with, whether they were a franchise or not, right? So they're going to have to comply with, minimum wage laws, non-discrimination laws. If it's somehow a union shop, have to comply with the National Labor Relations Act and all that goes along with that. But there's a concept out there called joint employer, right? Which has been out, frankly, joint employer has been a thing since the National Labor Relations Act was passed in the 1930s. And basically, what the joint employer says is that if you have substantial and direct control over an um, employee's working relationship, you basically could be deemed an employer as well, right? So, for example, in the franchise industry, this comes up a lot and has been a hot topic in franchising. Also, a topic in the staffing industry as well, right? But what happens is if you are the franchisee is an independent business, right? So they've signed a franchise agreement and they're operating under the terms and conditions of their franchise agreement. They have to comply with all the standards and specifications of the franchise. If the franchisor crosses a line with the franchisee's employees, right, they try to exert too much control over those employees, they could be deemed a joint employer. So, for example, if they were telling the franchisee who to hire, if they were sitting in on interviews with the franchisee's potential managers or potential hourly employees, if they were writing the employee handbook and requiring that the franchisee use that handbook, they could possibly be deemed to be a joint employer. So this
So
has been
that
out.
if I'm the employee and I am mistreated in my employment, I could sue not only my employer, the store that I work at, but I could sue the franchise company based in New York or Chicago or wherever the franchisor is based.
That's correct. And that is a lawyer's dream, right? Because usually the franchisor has what's called the deep pockets, right? So usually the franchisor has a lot of funds to pay damages and whatnot.
And I
So
could
for the
form a
long,
class action and everything else.
That's exactly right. So for the longest time, you had this rule, which was the substantial, direct, and immediate control. I made some notes because some of the stuff starts rolling into each other. So that was always kind of the rule, but a lot of this depends on who is on the National Labor Relations Committee, National Labor Relations Board. And so, under the Obama administration, this became more of a hot topic. And then restarted under Biden, where they kind of changed that standard or tried to change that standard to a direct or indirect control. And while that may not seem like it means, very much of a difference, it does because what the lawyers were trying to say when they had an aggrieved party, an aggrieved employee of a franchisee, for example, was that the mere fact that the franchisor was telling the franchisee what menu items they had to serve, how they had to serve them, how the clean the restaurant had to be, whatever, that was enough of a direct or indirect control that the franchisee's employees would also fall under that and thus make the franchisor a joint employer. As you can imagine, that sent shivers up a lot of franchisors' spines.
So it
We're now
really matters. It really matters who's in political office and what board members are appointed to various national labor relations boards, or who's running ERISA or who's running the FLSA. uh, people, the EEOC, all of those things really matter to businesses.
It really does. And so, what businesses really want is continuity, right? So I've always been a big believer that a business can operate with whatever the government throws at them as long as they know what the playing field is, right? What makes it hard is if you're playing on a 100-yard playing field and all of a sudden the government says it's a 200-yard playing field, right? That makes things very, 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 very difficult. So there's been a recent piece of legislation that's been introduced, I believe, in both houses of Congress now. The American Franchise Act. I know the International Franchise Association was a big supporter of that, but not just the IFA. There's a lot of other organizations that were a big proponent of it as well. That would basically clarify exactly what the standard is under law versus under regulation. And so, again, franchisors and all employers will know exactly what the playing field looks like.
What about the swimming pool manufacturing and pool supply industries that you've been part of? I know you were a CEO in that field as well. Are there additional federal rules that apply to manufacturing or swimming pools that might not apply to hamburger restaurants?
Sure. So I've been involved in the swimming pool industry for about the last 7, 8 years of my career before I retired, both as CEO of United Aqua Group, which is a swimming pool buying group, and then as a COO of Leisure Pools, where we were setting up a franchised pool service company called Ultra Pool Care. And so in that, I kind of ran the gamut from manufacturing to pool retail stores to pool service, right? And so they all have a little bit of different nuances. So for manufacturing, obviously, you're going to have to deal with OSHA, right? And all the OSHA regulations, make sure that the workplace is safe, especially when you're dealing with chemicals. Um, I know at Leisure Pools, they were building fiberglass pools. I had never ever seen anything being built with fiberglass, but obviously there's a lot that goes on there, and so OSHA is gonna kind of say grace over that. When you're dealing with chemicals, right? So if you are a pool retailer or if you are a pool service guy, right? The guys in the truck with the poles hanging out the back that come and make sure your water is safe and has the right amount of chlorine and whatnot. They're dealing with chemicals and a lot of different chemicals. So there's going to be all sorts of regulations over how those chemicals are stored, where those chemicals are stored, what chemicals can be near other ones, because obviously certain chemicals, if they mix, it's not a good thing. And so you have to be very careful about that. So there are a lot of regulations in the pool business that obviously are very different from the restaurant business.
We've been bringing up mostly federal laws, but I'm sure there are state regulations as well, especially in places like California. Certainly, you've done business in California, I know, and that's thought of as a terrible place to have to do business because there's such a difficult governmental environment that you face. California or anywhere else, what are some of the differences between the states as far as how they go about regulating businesses?
Well, California is a good example because a lot of things start in California and then they spread eastward, right? So a lot of things that are considered out of the box or perhaps, unorthodox start out as a law in California and then maybe within 10, 15, 20 years, it may be a law in 10 or 15 other states as well, right? So California is always kind of a bellwether to watch for some of these things. So here's what I consider something that is very different and had to be watched in the restaurant business, right? So let's talk about minimum wage. So the federal minimum wage is 7.25. It's been 7.25 since the year 2009. Okay. But a lot of the states have gotten into legislating minimum wage and higher minimum wages. A lot of localities have gotten into legislating on the minimum wage. And the highest minimum wage in the country is in a town in Washington, I think Tukwila or Tuwil, I'm not going to pronounce it. Anyway, it's over $21 an hour now.
Mm.
Seattle is $20.90, I believe. Well, California as a state, their minimum wage, as of right now, I believe, is a little over $16. But a couple of years ago, they passed a law that said if you were a fast food establishment, a fast food restaurant, that your minimum wage had to be $20 an hour. And they set up what they called a fast food council, made up of people appointed by the governor that could continue to raise the minimum wage just for fast food restaurants and set other pieces of employees' work. So they could set standards for the employees in these fast food restaurants as well. How did they define fast food restaurants? Any restaurant with limited service that had 60 or more establishments across the United States. So a lot of people can say, well, okay, if McDonald's has to offer $20 an hour, right? Or Burger King has to offer $20 an hour, or Jersey Mike's has to offer $20 an hour. But what a lot of people forget, going back to the franchising that we talked about, is that most franchisees are independent businesses. They may only have one or two McDonald's or one or two Jersey Mike's. They aren't McDonald's, right? They're independent businesses that have one or two establishments in the state. Doesn't matter. The way California defined it is because Jersey Mike's has over 60 across the country, because McDonald's has over 60 across the country, we don't care that you're only a single or a 2-unit or a 4-unit operator in California. You're going to have to comply with $20 an hour. It's very difficult to make money in a fast food establishment paying your employees $20 an hour. So what do? You do a couple of things, right? You either start cutting hours across the board, or you make do with less employees. So I've always thought some of these laws have again, I think they all come from a good place, but they don't think out where they're going to go. So it ends up with, I think, a lot less people being hired. And let's be honest, should some 16-year-old high school kid during the summer be making $20 an hour to, flip a burger or run a cash register machine? The point of minimum wage was really to allow people who were starting out their work life to get some on-the-job training and be paid a fair wage, right? It really wasn't meant for people to raise families on. And I know a lot of people do, some people do. But basically, I think what you're doing is you're hurting the people that really need to be helped the most, which are younger people just getting into the job force, just getting into the working world. And those jobs aren't going to be there.
Hmm. How would you describe, from the business owner's perspective, the burden of complying with all of these laws? I imagine time and money are two of the biggest.
Well, it's time and money, and a lot of it ends up really being money, right? Because some of the stuff is just so nuanced that you don't want to try and figure it out yourself, right? So you have to go to an expert, which is whether that's a consultant or an attorney or whatever the case may be to figure this out. I mean, when Obamacare was passed in 2009, right, the restaurant company I was working with, we were scrambling to figure out, do we fall under Obamacare? Do we not? Because the definition was 50 full-time equivalent employees, right? And so we had to figure out, because we had some company stores, it wasn't just our corporate employees, we had company stores. And so we had to figure out, do we have 50 full-time equivalents? And so you spend a lot of time on that. And then you have to go to lawyers or your insurance agent and figure out, how do we comply? What's this going to do to the cost of our health insurance? And so there's a whole myriad of things that, yeah, it's definitely time and it's definitely money. And the time that you take to figure this stuff out is just time you're not spending on the business, right? And making the business better. So it's tough.
Government approvals are another thing that I know takes a fair amount of time. If you have to get zoning approval to build a new location, or any kind of building permits and approvals of your franchise before you can sell franchises, all of those things are cause delays, which can affect things.
Well, let's talk about, just really quick, let's talk about swimming pools, right? So again, when I worked at Leisure Pools, we manufactured fiberglass swimming pools. And I wasn't really on that side of the business. Again, my job was to set up a swimming pool service company. But again, I knew what was going on. So there were some localities that if someone ordered a fiberglass swimming pool from one of our dealers, right, they could basically have it in the ground in a few weeks or a month, right? Assuming that our dealer had that pool in stock or whatever the case may be. But there were some parts of the country, it could take 2, 3, 4 months by the time you get through the permitting process, both from a state level, from the locality level. If you live in an HOA, if you have an HOA on top of it, right, which is just another form of regulation, you've got to deal with that. So it's tough. It adds a lot of time and effort and price to the consumer.
Now, I want to take this in a quite different direction by bringing up a very specific law called the Virginia Graham Baker Pools and Spa Safety Act. I don't think most people have probably heard of this, but you probably heard of the incident that gave rise to it. A young girl in 2008 was a 7-year-old girl was sucked into a hot tub drain and she was seriously hurt. I believe she may have died. And the same thing happened to a girl named Abigail Taylor in my state of Minnesota the previous year. So then there are laws passed about how drains have to be made. And one can understand the pressure of Congress to put regulations in place when there's been a tragic accident in a certain situation. Uh, right, but tell us how that kind of a single incident or couple of incidents can then lead to a broader regulatory scheme.
Well, you're exactly right. That's exactly what happened. So, Miss Baker was, I think, a 7-year-old, a very proficient swimmer, from what everyone said. And I believe it was her hair was sucked into a drain that had obviously suction behind it, and she couldn't get free, and she drowned. And then the following, I think it was 7 years later, I think that was in 2002. And then in 2007, the young girl you mentioned from Minnesota, she was actually basically disemboweled when she somehow got sucked into a drain. I don't think she died. I know Miss Baker did, but I don't think she died. And so, yeah, basically, Congress passed an act that said that there had to be, there's a lot of nuances, but basically, you had to have a cover over a suction drain, which makes sense. Um, you do have to ask the question of, I don't know if you realize this or not, but Miss Baker was actually the granddaughter of James Baker, who obviously worked for a lot of different administrations, presidential administrations, and you have to wonder if maybe she had a different name, if this would have gotten the attention that it did, and a law passed. Because when you look at the number of incidents that there were on an annual basis, it isn't like there were hundreds and hundreds of incidents. I think in '07 there were 60 or 70 incidents, only a few of which caused death. Now, again, any death is terrible, so I'm not saying that it should or shouldn't be done, but obviously, living life, right? When you just living your life, there's risks involved, and so this is a perfect example of something that maybe wasn't a big issue affecting a lot of people, causing a lot of deaths and serious injuries, but certainly got a lot of press, and then with the right people involved led to a law.
Well, and then you hear some of the ones that get poked fun at are, one guy fell off a ladder, and now there has to be all these warnings on a ladder that say don't stand on the top of it, and
Right.
things like that. It seemed like they uh, just couldn't common sense take care of this, rather than having to put all of these warning labels on because one bad thing happened to one person.
Yeah,
Lawnmowers the
exactly.
same way. And there's a cost associated with all such regulations in business. I want to shift gears again as a tax-paying and law-abiding citizen and not a businessman. I think about the cost impact to our U.S. government budget and my fellow taxpayers and yours. Reduced regulation means smaller government. We need fewer government agencies and government agencies workers to carry out all of these regulations, to pass them, to refine them, to make sure they're being complied with. Reduced regulation, smaller government, that in turn means a smaller federal payroll, less space needs for the federal government, less equipment. Uh, Taking off your business hat and just leaving on your taxpayer hat, which is probably a big one. How do you feel about the budgetary impact of the regulatory regimes we have discussed?
Well, it's huge. I think, as you alluded to earlier, and I actually did a little research on this. I guess last year, the Federal Register, right, which is the daily publication that lists all the proposed rules and final rules for the government, last year had 106,000 pages, which was the most that it's ever had, and 45,000 of those pages were dedicated to final rules and final regulations, right? And so this gets into what I think is been a hot topic for the Supreme Court for the last few years and is going to continue, right? Where basically Congress passes a law, right, that might be 3 or 4 pages long, right? And then basically unelected bureaucrats make all the rules and regulations that basically interpret the law, right? And rules and regulations, I read somewhere years ago that when the Americans with Disabilities Act was passed, right, under President Bush in I think 1990, I think the original law was 3 pages or 5 pages long. I don't remember. But by the year 2000 or 2005, the regulations could have filled 3 phone books.
Hmm.
Again, don't know if that's true or not, but I remember reading that. And when you think about it, right, all these rules and regulations, which basically have the force of law because they're interpreting that original 3 page or 5 page or 10 page law, are out there. So you have all these people that are earning salaries basically, and like you said, they have office space and computers and expense accounts and everything that goes along with it, are basically coming up with all these rules and regulations. It's a problem, and you're right. As a tax-paying citizen, it's an issue, and I think for the next 5, 10, 15 years, this is going to continue to be a hot button for the Supreme Court.
So, what's the proper line? Just as a citizen of this country, we can't live in a completely unregulated Wild West society. That would never fly nowadays. But we also can't really live our fullest and best lives in a nanny state either. Is there a place to balance, or is it a case by case basis?
Yeah, I think it's tough. I mean, I think it's probably a case by case basis, but I think absolutely there have to be laws and regulations out there. But I think they have to be well thought out, and I think more importantly than just trying to react to what's ever in the press that day, right, or whatever a group of people who's part of your constituency is up in arms about. You really have to think about what's the long-term consequence, right? I always talk about things being is it something, is it a marathon or a sprint, right? And I think a lot of times we deal with things as a sprint and we're not thinking about what it is like a marathon, right? And what is going to be the long-term impact of some of these things. And you know, as you know, once a law is passed, it's so hard to repeal it, right? It's just so hard because it just takes on a life of its own, and you get the bureaucrats and the agencies involved, and it just gets to be so tough. So I think there needs to be a lot of introspection, but introspection requires a functioning legislative branch. And probably a topic for another podcast. I don't think there's been a functioning legislative branch in this country for 20 years, maybe 30,
Yeah.
right?
Yeah, well, that's a good perspective, and this has been very helpful, Pat. I knew you'd be the right person based on your long and illustrious business career and your legal background to talk about these topics. So, thank you very much for your time today. I'll close us off with a concluding remarks, but I just wanted to say nice job, and we'll to have you back on the podcast again at some point down the road if a similar topic that would benefit so much from your business experience comes up. Thank you.
Well, thanks, Quentin. I've enjoyed our conversation today.
All right. Now, to these issues, my nonprofit, Principle Based Politics, and I personally would apply three governmental principles. One is freedom and free enterprise. The second is limited government. And the third is protecting the vulnerable. As you can imagine, this is a balancing act required for these, and I believe limited government should be the filter to forbid passage of any and all unneeded regulations or those that could be imposed rather than by the federal government. They should be imposed elsewhere, either by states or cities or some other entity could impose and manage those better. Only when there is a need to protect the vulnerable that outweighs the harm to freedom on a particular topic and free enterprise, then and only then does federal intervention seem to be necessary for protections to be enacted. And in such cases, Congress should enact straightforward laws that will be clear enough for the federal agencies to administer and enforce, and clear enough for businesses to follow. Any agency regulations must flow directly from the purpose and history of the legislation. On the other hand, when the burdens on individual and business freedom outweigh any potential assistance to the vulnerable, or when another governmental body could be more effective, Congress and the federal administrative agencies should just simply butt out, in my opinion. Any unnecessary, confusing, or unduly burdensome regulations already on the books should be streamlined or repealed. So, with that little homily, thank you all for listening to episode 18 of the Extremely Non-Extreme podcast, and especially again to Pat Walls, who's been an excellent guest. Please subscribe to this YouTube channel or enter your name and email address on my website, principlebasedpolitics.org, to receive both my future blog and podcast links. Thank you all again, and we'll see you next time.